Hi everyone, my name is JT. I am finishing up my master's program at Colorado State University currently in the Student Affairs and Higher Education program. This presentation is going to be going over the case of Rynasko versus New York University, NYU, for my Law and Student Affairs course. Hope you enjoy. First, we will go over some of the basic details and facts regarding the case analysis. The plaintiff, otherwise known as the appellant, is Christina Rynasko in this case. This is individually and on the behalf of all the other individuals correspondingly situated in regard to the case. The defendant, also known as the appellee, is New York University, NYU. This case is concerning the spring of 2020 pandemic semester, where NYU suspended all of their in-person instruction and services for their students. Christina Rynasko felt as though her daughter's education and resources were inadequate in comparison to what the school had promised per contract. Unjust enrichment is the legal terms Rynasko used regarding her daughter's education for the case. Therefore, her primary goal was to partially recover the tuition and fees she allegedly paid for in regards to her daughter's semester. Next, we're going to go over the primary history of the case. Christina Rynasko appealed the U.S. District Court's decision to dismiss her claims against NYU. The court then denied her request to add another plaintiff to the case. This plaintiff would have been a current student of NYU who would have experienced the 2020 spring pandemic semester. The plaintiff claimed that NYU had a violation of their academic contract and promises to their students, specifically her daughter. This was considered a putative class action suit case against NYU to partially retrieve the tuition and fees from Rynasko's daughter, spring 2020 semester. The court then granted motion for NYU to dismiss because, according to the court, Rynasko lacked standing to show adequate proof that the payments for tuition and fees were specifically from Christina herself. She couldn't allege that the paid money was identified as hers, this as well as the case focusing on her adult student and not herself. The court then denied Rynasko's request to amend her complaint to add a current NYU student as a plaintiff to the case because the amendment would have been considered to be futile. Moving on to the court's final decision. It was concluded that the district court had correctly determined that Rynasko lacked standing because no injury to herself was specifically shown. Instead, injury was shown to her daughter, who is not the original plaintiff. Therefore, the court correctly determined the outcome. Although the amending of the complaint to add a current student of NYU to the case as a plaintiff would not have been futile. If the student was added as a plaintiff to said case, they most likely would have had sufficient evidence and plausible claims to support their case in the unjust enrichment and lack of services and resources provided to Christina's daughter, as well as the tuition and fees having a more plausible source, considering her daughter is an adult student. Some interesting details regarding the case worth noting are that the New York courts know that the relationship between a university and its students is contractual automatically, although specific promises provided in a school bulletin, class curriculum, and university handbooks can also determine the presence of implied contracts. This provides leeway to the academic institution in situations like this. Something else I personally felt was interesting about the case was that Christina Rynasko took this matter to court on the basis of only enrolling her daughter into NYU and paying the tuition and fees based on the promise of in-person course experiences. She claims that she otherwise would not have enrolled her daughter, and I find this interesting since every single in-person based student in the United States during this semester of spring 2020 had the same intentions. It was not the university's fault that a pandemic occurred, and the majority of academic institutions were simply following the lead of not only the CDC, but other academic institutions. We all had a different experience than we wanted to and expected at that time, but we didn't all try to take our universities to court over the matter. So I did find that interesting. Why is this case important to student affairs professionals and academia as a whole? This is important to student affairs primarily based on the fact that laws, policies, and university contracts are constantly evolving, and there is no predicting extreme circumstances like a pandemic. It is important to stay constantly up to date on what's legal, what is permitted, and what is not, as well as having in the back of everyone's head all the time and the proper training of what's ethical and what's unethical in terms of policies. I would say it is also really important for student affairs professionals to have a say in the university contracts that are in place. They are working on the front lines with the students, and they know the higher concerns of a campus from a student perspective, maybe a bit more than other people on campus do. It would also be beneficial to keep in mind that the specific wording that's used in a contract is to protect the university against lawsuits like this, to be extra mindful of the building of that wording for the contracts. Thank you for your time and overall observation of this case analysis and briefing.